Good evening, friends, and thank you for choosing NewsDecoded, the place where complex stories unwind and hidden threads come to light. If in-depth investigations and fearless analysis matter to you, go ahead and tap that subscribe button, ring the alert bell so you never miss an update, and share your thoughts in the comments below. Your engagement fuels the journalism that keeps power in check, so let's keep this conversation vibrant and alive. Tonight we delve into a legal drama that is equal parts courtroom chess match, political suspense novel, and societal reckoning. At the center of it all, Ghislaine Maxwell, once the confidant and accomplice of the late financier turned convicted sex offender Jeffrey Epstein. Maxwell is serving a 20-year sentence after a jury found her guilty on multiple counts related to sex trafficking of minors. Her conviction survived the first round of appeals, and under normal circumstances that would be the final chapter. But these are anything but normal circumstances. Maxwell's legal team has pushed the case up one more rung, petitioning the United States Supreme Court to review her conviction. Statistically, that is a moonshot. Fewer than 2% of criminal petitions are granted what the justices call a writ of certiorari. The High Court reserves its docket for matters that crack constitutional bedrock or settle splits among appellate circuits. On paper, Maxwell's appeal seems to offer neither. So why is the petition attracting this much attention? Because the Department of Justice, now led by Attorney General Pam Bondi, has asked for 2 extensions before filing its response, and the final deadline lands tonight. Before we press forward, a quick refresher on how we arrived here. Jeffrey Epstein was first investigated for sexual abuse as far back as 2005. Despite dozens of accusers, he secured a controversial non-prosecution agreement in 2008 that critics say allowed him to dodge meaningful consequences. That agreement, negotiated in secret, hidden even from victims, and later declared illegal by a federal judge, casts a long shadow over every decision the Justice Department now makes. When Epstein was arrested again in 2019, public fury exploded, but soon after, he died in federal custody, sparking endless speculation that powerful allies helped silence him. The absence of Epstein elevated Maxwell from supporting player to primary source of answers. During Maxwell's 2021 trial, 4 women testified that she groomed them as teenagers, some as young as 14, luring them with promises of mentorship or financial support. Jurors heard detailed accounts of massage rooms turned crime scenes, private planes nicknamed the Lolita Express, and sprawling estates monitored by staff who knew better than to ask questions. Emails, flight logs, and photographs painted Maxwell as gatekeeper, recruiter, and enabler. After 12 days of testimony, the jury deliberated for 5 and convicted on 5 of 6 counts. U.S. District Judge Allison Nathan imposed a 20-year sentence and a $750,000 fine, citing Maxwell's direct and repeated participation in a scheme that spanned a decade. On appeal, her lawyers argued evidentiary errors and juror misconduct, but the Second Circuit rejected those claims. Now, with their Supreme Court petition, the defense spotlights questions about statute of limitations, jury instructions, and alleged violations of her right to a fair trial. Each argument is meticulously crafted to tempt at least 4 justices to say, "Let's take another look."
For observers steeped in ordinary practice, delays themselves are no red flag. Appellate work is, well, document-heavy. Federal lawyers may simply need extra time. Yet the Epstein saga has never been ordinary. In the public imagination, it represents 2 explosive questions. How far did Epstein's web of sexual exploitation reach, and which powerful figures benefited from or concealed it? Every time the story resurfaces, those unanswered questions charge the air like a gathering thunderstorm, and the Department of Justice knows it.
Let's pause to set the procedural stage. After losing in the circuit court, a defendant has 90 days to petition the Supreme Court. The opposing party, in this case the DOJ, has 30 days to respond unless it requests more. 2 extensions imply something unusual behind the curtain. Perhaps the appellate staff is swamped. Perhaps morale has thinned because seasoned lawyers have departed, unwilling to serve under a controversial administration.
But there is a more provocative possibility. Officials are quietly negotiating with Maxwell to limit what she might reveal. Why would prosecutors entertain a deal with someone convicted of such heinous offences? The answer lies in leverage and fear. Maxwell remains the last living insider with first-hand knowledge of Epstein's client universe. She knows who flew on which private jets, who visited secluded properties, who crossed blurred lines. If she decided to speak fully and documents or corroborating witnesses backed her up, the resulting disclosures could scorch reputations, end political careers, and even trigger criminal investigations on entirely separate tracks.
Imagine for a moment that you are a risk-averse official in a Justice Department buffeted by allegations of favoritism. You appreciate that forcing Maxwell to litigate every point risks public filings, hearings, and perhaps subpoenas that drag sensitive names into daylight. You might explore paths to minimize damage, quietly agreeing to reduce a sentence in exchange for silence, arranging for the president to issue a pardon on his last day, or even moving to vacate a conviction under procedural pretext. Any of those maneuvers would be extraordinary, but none are impossible.
Maxwell's lawyers understand this dynamic and are likely exploiting it. Their Supreme Court petition gives government attorneys a fresh deadline and a fresh reason to pick up the phone. The calculus is brutal. Cooperate now and uncomfortable secrets stay sealed. Refuse, and discovery requests, media interviews, and perhaps congressional testimony could follow. Maxwell's camp has already hinted she is willing to brief lawmakers. That single promise is a sword hanging over Washington because congressional subpoenas carry real weight, and televised testimony can reshape public opinion overnight.
The Constitution grants presidents broad power to pardon federal crimes. Historically, pardons materialize at the end of terms when political cost is lowest. If justice signals, even obliquely, that a pardon awaits, Maxwell might accept several more years behind bars as the price of eventual freedom. We have precedents. Gerald Ford pardoned Richard Nixon after Watergate. Bill Clinton issued a raft of last-minute pardons, including some for political allies. The outrage fades, the paperwork endures. Skeptics may wonder whether such a clandestine agreement could remain secret. In practice, it is surprisingly feasible. Communications run through attorneys shielded by privilege. Draft pardons lie locked in safes. Negotiations masquerade as scheduling delays. Unless a participant breaks ranks or a document leaks, the public may never know, at least not until the moment a pardon is signed and delivered to the Bureau of Prisons. Congressional committees add another wild card. Maxwell's promise to cooperate with lawmakers is not idle. Should control of key committees lie with politicians eager to embarrass the administration, subpoenas could fly. Televised testimony, even if limited by grants of immunity, creates indelible imagery. And once a single page from the so-called Epstein files becomes public, momentum favors disclosure of the rest. Governments can slow leaks. They rarely stop them. The Bureau of Prisons introduces a practical wrinkle. Administrators can restrict inmate access, delaying or denying press interviews under the banner of security. Maxwell could be placed in special housing, her phone calls and emails monitored, visitors limited. Those steps buy time but carry reputational cost. Journalists excel at framing denial of access as an admission of scandal. The harder officials clamp down, the more oxygen they give conspiracy theories.
Supreme Court appointments over the last decade have tilted the bench in unpredictable ways on criminal justice. Several conservative justices espouse strong views on procedural fairness and occasionally side with defendants in high-profile cases. Liberal justices emphasize victims' rights and systemic accountability. A Maxwell cert grant could scramble usual ideological lines, producing an unexpected majority. That unpredictability adds yet another headache for DOJ planners.
Meanwhile, Epstein's victims continue to seek justice in civil courts. A renewed spotlight on Maxwell's appeal could galvanize those suits, encouraging more witnesses to step forward. The interplay between criminal appellate strategy and civil discovery is delicate. Statements in one arena can ricochet into the other. Defense attorneys often prefer a global settlement that seals everything, while prosecutors worry about collateral damage to third parties. Where does all of this leave us on deadline day? The Department of Justice faces a three-pronged dilemma: file a standard opposition and risk months of unpredictable litigation, confess error and face immediate accusations of corruption, or remain silent, triggering procedural chaos and a blizzard of speculation. Every option is radioactive. Each threatens to illuminate corners that powerful people prefer to keep dark. For the broader public, The lesson is stark. Transparency in cases involving systemic abuse must be relentless, or cynicism metastasizes. Survivors who testified against Maxwell did so at immense personal cost, believing in the promise of accountability. Any backroom compromise that muffles their voices betrays not only them, but also the principle that no one, absolutely no one, is above the law. Conversely, weaponizing victim narratives for partisan gain would be equally unconscionable. True justice demands focus on facts, not partisan scorekeeping. As the clock ticks toward midnight on this filing deadline, remember that the law often moves in shadows before outcomes hit the front page. Extensions, sealed motions, whispered negotiations, these aren't mere technicalities, they're levers that can redirect history. When tomorrow's headlines arrive, whether proclaiming a routine brief or a bombshell concession, scrutinize what lies between the lines. Ask why decisions were made, who benefits, and who was left unheard.
Yeah, and honestly, it's a reminder that the pursuit of justice is rarely straightforward. It's messy, it's political, but it's essential.
We will, of course, track every development. Should the Supreme Court docket reflect an unexpected government position, or should a surprise motion appear in the lower court, you'll hear about it here first. Our commitment is to follow the paper trail, decode the legal jargon, and bring you facts unvarnished by spin. If tonight's exploration shed new light on a story you thought you already understood, let us know. Drop a comment, challenge our assumptions, suggest angles we should pursue. And if you haven't yet joined the NewsDecoded community, now is the perfect moment. Subscribe, give this video a thumbs up so the algorithm shares it with others hungry for truth, and consider sending the link to friends who care about justice as much as you do. Until our next deep dive, stay curious, stay informed, and remember, sunlight is the best disinfectant, and together we can aim it exactly where it's needed. This is NewsDecoded, signing off for now.